Oh, yes. They opened right back from lunch. They just boop, boop, and right to the sidebar. That would be number 8. I think I'm going to be 10K richer today. Oh, gosh. Hi, couch. I keep typing. Court resumes with a sidebar. Then, of course, we'll bring the jury in. I just thought that was too funny. I could have been annoyed for them starting a few minutes early because, they did. Like, how dare they? They're never on time. So I rushed back. But nope, there they go. She's like, "Did you want to talk to me?" Like, no. Sidebars are becoming as traditional as gropes with gin. I agree. I agree. Quite common. I just can't imagine there's so much they have to settle back and forth, like over and over and over again. Like, it's ridiculous. Hope everybody enjoyed your break. It's a bit cloudy out here today. Although the temperature was nice, it's like around 67. Very funny, Jen.
You are unmuted.
We're waiting for the jury now. Yeah, that can be dangerous, Jen. Those tiny buttons on the phone. Why the jury's in?
For the water, I'm good.
Seems like they're all in a good mood. Must have been a great lunch.
Scores of session, please be seated.
And here we go.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Good afternoon, Dr. Scordi-Bello, and welcome back.
Thank you.
I want to move on to a slightly different aspect of the hypothermia discussion. So you acknowledged previously that hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you acknowledged that in your grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And you indicated in that grand jury proceeding, generally that diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy, you observed for example, the lining of both the stomach and the pancreas. Is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the stomach as part of Mr. O'Keefe as part of the autopsy?
Yes, I observed some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the pancreas did you observe?
I examined both the external surface and the tissues around it, as well as the pancreas itself by making several cuts.
And there was also a histopathology report that was relevant to both the stomach and the pancreas, correct?
Correct.
Histopathology?
Spell it, Mr. Alessi.
Histopatholgy. So that histopath information informed your hypothermia analysis, is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So do I have it correct? And let's start with the pancreas. That you noted the pancreas was congested and diffusely hemorrhagic. Do I have that correct? And you feel free to look at your report, please.
I will.
And I specifically, if it helps, I'm
Yes.
looking at
Page 4.
the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1. And then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And the next page is the histopathology.
Yes.
All right. Are we sort of oriented in the same location?
Yes.
All right. So let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's parenchymal hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time, so now I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances I was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry,
Rephrase it.
I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me. But I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document that
Sure.
might refresh your recollection on what that, a document that may refresh
She
your
said
recollection?
sure. I
Thanks.
think you heard her.
I did. Thank you, Your Honor. May I approve? May I approach, Your Honor?
Yep.
Thank
Just
you.
show Mr. Brennan.
Yeah. May I approach, Your Honor?
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you, just that section, up to here. And once you're done, if you could kindly look up and let me know.
Okay.
Dr. Scordi-Bello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital. And it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustain. Jurors disregard that. Move on with this, Mr. Leslie. With this, but just move on.
Yeah, yes. In terms of the differential diagnosis concept that we were talking about before, based upon your refreshed recollection of circumstances of death as discussed in the death notification report, based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
I'm going to allow that.
initially, no.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony on that subject?
All right, I'll see you at 10.
This would be sidebar number 9. Here we go. Sidebar number 9. Again. On whatever was that playing in the... Oh gosh, look at it. It says 39 because the button didn't go again. I'm going to do that one again. Push it. Jesus. There. There it is. It's number 9. Oh, and now the feed is going to go wanky. All right, hold on. Let me check the feed. I've got some buffering, which I'm not too happy about. Okay. Which I just corrected. And it's buffering again. I don't like it. I don't like it at all. What is that? Don't make me go looking for another feed. Ay, ay, ay. Come on. Ay, 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 ay. Today. Oi, jeez. They switched to a different feed because they lost it again. You see that? They brought up another radio station. I mean, another station. We'll just leave it. They had trouble with their feed. I'll just go with the feed that they chose. There are a few others, but it's hard to tell which one's going to be steady. Yeah, we'll just stick with that one until they fix their own feed. If they fix their own feed, they'll usually switch it back. But at least, at least we have a good one up here. Yeah, it's new. This is Boston 25. We were with NBC 10 out of Boston. In their feed went wanky. And while I was looking for a new feed, Boston 10 switched to Boston 25. So they're using the Boston 25 feed. So yeah, I don't know what happened. But usually if they will straighten it out themselves, they'll just switch over and it won't matter. Like they'll switch it themselves. I won't have to move. Well, that was sidebar number 9.
May I, Your Honor?
Yes.
Thank you. At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you recall that?
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation.
It's possible.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach, in the pancreas, would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
But do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of
The
the
inner
stomach.
lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach, in the soft tissues of the torso.
Okay. So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine and assume 100 compressions per minute. That would result in 3,700 compressions from a Lucas machine, correct?
Correct.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees. My opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was, does your report state anywhere the words Lucas machine?
No,
And you agree that a Lucas machine could cause hemorrhaging to the pancreas,
it can cause hemorrhage in a lot of tissues,
but including the pancreas.
including the pancreas.
If you see hemorrhaging of the pancreas and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us the spelling of that?
Would you like to give it?
If you'd like me to, I'm prepared to give
ahead.
it. Thank you. Wischnewski. So, can you just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, amongst other things. They're believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't,
So
Do you
yeah.
recall?
Hold on.
Okay.
Move on. The objection sustained. So
Okay.
you're asking it, yes, go
Okay.
ahead.
Thank you. There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I want to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that. So now I want to move to the stomach.
Okay.
Do you believe all hemorrhages in the stomach are Wisniewski ulcers?
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with your Honor's permission, publish some depictions of first the gastric mucosa, and then start with that, Your Honor, publish that.
All right. So this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay.
Start with that.
What number?
Your Honor, just to.
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's right.
Pardon me?
It's NN right.
And I'd like to move NN into evidence at this time.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
164.
May I, Your Honor?
Yes.
Dr. Scordi-Bello, I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at on the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164. Dr. Scordi-Bello, do you recognize 164 as well, you describe what 164 is.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink red surface is the mucosa. That's the lining of the stomach. And you had used the word rouillé before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to
Correct.
them as hemorrhages.
Correct.
Okay, so what I'd like to do now is to, if I may approach, Your Honor,
Yes.
to the chalk.
Exhibit MM.
With your Honor's permission, may I show Dr. Scordi-Bello the chalk that's marked for identification as MM?
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scordi-Bello, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach, again, the mucosa with hemorrhage.
Your fault for the sorry, not your fault.
Your Honor, can we take a break?
Yes,
from jurors?
yes.
Please rise to the jury. Jurors, right this way, please.
I'll see counsel at sidebar, please.
The sidebar. We're getting closer. We're getting closer. That's sidebar 10. Ooh, it's heating up quick. Somebody has to go poo-poo. I don't know what's going on, Nick. I don't know. Yeah. You might just have to call the court to make them stop. Good luck there, Maya. Yeah. They love their sidebars. It's going to get hard for them to break the habit. I think they do more sidebars than anything. She didn't say that you are an ass in her report, even though that. Now, Liam. Really, I mean, just because she didn't use the words. I do not like when the attorneys think they know better than the expert witness, especially about the expert witness's subject. This trying to trip people up on a word here and there. That's not going to look good for the jury. That misstep there that he just did, well, that just shows he's not really leading to anything here that they should be paying attention to. Because he's going to lose them. Oh, one of the jurors, yeah. Is that it, Mandy? You thought it was the bailiff who said that about taking the break? Yeah. Well, didn't they just got back? I mean, Yeah, he's still going. Mandy, I see you came in and goes, what? He's still going. Yeah, of course he is. He's like the little energizer Alessi. But he's really not going anywhere with any of this. I don't see any points that he's with any of it. There's no gotchas. She is very pragmatic. Like he's not going to trip her up. I don't even know what he's trying to trip her up on. Yeah, right, Liam. You know it was the intern. Yeah. Lunch is kicking in, Pete. Yeah, I agree. But maybe the. I mean, it's not going anywhere. I want, the judge's going to give him time, but still, if it's not going anywhere, it's really a waste of everybody's time. And he's running the risk of, losing the jury. Uh, I think he may have. I think you might be right there. I can't imagine. I'm going over to the socials to see if anybody said anything about the jurors' faces. which, occasionally they do. Taking a recess at the request of a juror. A bio break. That's what they're calling it. What a clever way. So there's also the Koberger hearing going on this afternoon, one of the last ones before trial starts in August. Wednesday. Oh. I know all those judges, all those people who say the judge is biased against the defense are obviously ignoring how much leeway she gives them to fish about for tidbits in expert testimony. Exactly. That's what, another 2 hours today. Will they break the sidebar record? I think they will, Gene. I think I'm going to get richer. Hello, Angie. Welcome. Yep, the same voice said, Your Honor, can we take a break? And the jurors right this way. Yep, bailiff then, court, one of the court officials. He's like, bio equals poo, people. Like, I just thought it was a nice, polite way to say it. Juror needs a bio break. I think that's great. Yeah. Oh, well. And I didn't mark the time. I think it was at least 5 minutes ago. Okay. I need more coffee. I don't know about you guys, but this is getting like really to be sidebar mayhem here. Although I can't really call it a sidebar, can I? If they took a break, huh? Is Maya going to get one back? Do I have to negate that one? I think I called it a sidebar before I realized what it was. Did you see the clip of Karen Reed's dad saying that she wasn't? Yes, I was talking about that this morning, Mandy. That he went right out there, took a mic in front of with the reporters and said, "Oh no, she wasn't sick. She just needed her rest." Yeah, she's just tired, and so yeah, that's why they shut the court down. What a waste of taxpayers' money, and definitely not cool. Maya, I think I'm going to have to give you that sidebar back because this is actually a bio break instead. Yeah. So we're still at 9. Yeah. So 4 more and I win. Yeah. Oh, you did? That's good, Liam. I'm glad that's working out. Hopefully everything works out for that pup. Wait, was she excused and now they're inside? You know, they did get up, didn't they, Mandy? Wait, they did leave the table, didn't they? All right, so I'll have to wait and see when the fan comes down, if they are up, if they are coming back from the judge's desk, then we call it a sidebar. She did call the line. Okay, so we're leaving it. Sorry, Maya. We're going to leave it as 10. So she did call them the sidebar, and then they called for the bio break, right? Okay, so I didn't hear incorrectly. All right. Yeah. Sorry about that, Maya. She did call them the sidebar right before they called bio break. So it's a twofer, but it's still 10. Yeah. Are you sweating? It's getting close. And we still have an hour and 20 minutes of testimony or court. I don't know if it'll be testimony at this rate. Oh, yeah. Sorry about that, Maya. You know, you can't blame me. Blame Judge Cannone. Blame the judge. Called them as they left. Okay. All right. I guess she's using the time wisely, right? You're gonna have to petition the court there, Maya. Here we go. This is a different angle. You demand a recount. You can go back and count them in the chat if you'd like. I posted everyone. I may have did not press down the number key hard enough and it came up as a 3, but I did post everyone. Yeah. And I have help too, because Rocket Couch kind of helps me keep track of them. So if I get out of hand. Mm. It's a different angle on the fan. I guess they didn't get their own feedback because they're still using Boston 25. Breaking news, random. Oh, wait, I got to put this one up. This is good. Breaking news. Random internet waffle calls for retrial on account of juror's bladder causing lost bet. Okay. Oh, my God. Oh, considering that Couch is my moderator, I think he would have to recuse himself for potential conflict. You mean recuse, right? Or accuse. I mean, either way. But still, he's fair. He can count. Just because he's my moderator doesn't mean he's not a fair counter. But you don't think I posted it? No? Recuse, yes. Recuse. Yeah. That's what I thought. Or accuse. You're accusing him of being a bad counter. You know, I accuse Couch. What are you accusing him of, Liam? Being an excellent counter of sidebars? Oh my gosh. This could be a revolt. Give you a minute and you'll think of it. Is 10 now. Yes, I did. And I did above. I posted 10. I think so. Yeah. And then we went back and forth about the bio break. I feel Claire is more biased about my conduct than I am. Okay. Fair point. Fair enough. It's still 10. Like Maya, you're still gonna lose. You're gonna lose. I'm gonna be 10K richer. Unless this turns into be the longest sidebar ever, and then we just go all the way out. Oh gosh, now what? You're just getting your intern. You got Alessi's intern over there asking Chat GPT what Couch could be guilty of. Oh my. It's a shame that Alessi's intern can't get the witness to answer appropriately under the terms of what they researched. Yeah. No, she not having it. No, you don't think they have enough time to get to the other 3 today? Well, we'll see. Waffle's got his fingers crossed. It is a rather slow-paced afternoon of trial today.
Please be seated. Court is in session.
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I reapproach the witness?
Yes.
Dr. Scordi-Bello, you have in front of you, which has been marked for identification as MM, and you were discussing that. Do you recognize that document? Sort of start over to reorient. You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence. I object to Beverly as a child. I'll, you know what, if I can use it as a publication. Yeah, that's what I'll do, Your Honor. Thank you, Mr. Brennan.
So you can have it displayed.
Thank you. And again, I'll leave this hard copy with the court reporter, and we'll use the screen.
Oh, so it's not in evidence?
It is not.
It's marked for identification.
Yes, marked for identification, and we are with it. Mr. Wolf? Dr. Scordi-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe, this is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with your honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection sustained.
Could we, with your honor's permission, publish simply Mr. O'Keefe's
Yes.
gastric mucosa?
Yes.
Isn't it correct, Dr. Scordi-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So you can take that down, Mr. Wolf. Isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again. So what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10 and 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of continuing with hypothermia, let's go to frostbite. Do you note any evidence of frostbite on the deceased, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early morning? I'm sorry, I keep saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29, 2022, going through 6 a.m. on January 29, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature and a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So, at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy, whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident? Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs and I did not see any evidence of an impact site.
And can you elaborate to the jury what you mean by no evidence of an impact site?
I'm going to sustain that objection.
What do you mean in your answer, no evidence of impact injuries?
I'll allow that.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct? Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain from that impacted back of the head a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with your honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly state the foundation of it. Dr. Scordi-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
165.
Thank you.
There, Your Honor.
Yes.
Thank you. Dr. Scordi-Bello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolf publish
Yes.
165? Thank you, Mr. Wolf. So Dr. Scordi-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Could be consistent.
If we could, Mr. Woke, have the laceration to the nose. I'm sorry, hold off on a moment. Your Honor, Mr. Brennan has agreed to stipulate this going.
Okay, so like we can mark it.
166.
Oh, thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you. Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolf. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With Your Honor's permission, I would like to Mr. Brennan. Your Honor, Mr. Brennan has agreed to
Okay.
stipulate into evidence these two photographs. May I please have them marked
Yes.
as next to evidence?
It's 167 and 168.
Thank you.
I'm going to do the same thing if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to and these wounds to Mr. O'Keefe in your autopsy report?
Yes,
And am I correct that you noted that there was a pattern to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, I couldn't hear.
Ask another question, sustain.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No,
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
that is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
All right, thank you, Mr. Alessi, Mr. Brennan.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is 2.
is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes,
Is it important to have a complete statement rather than just part of a statement?
yes,
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago,
Okay.
but I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes,
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that.
Do you remember Attorney Alessi read you that part of your statement?
yes,
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
You, to complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
Okay. I can approach. Ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alessi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
You asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
You can read the rest of the answer that you weren't given when it was read to you.
Objection, Your Honor.
So this is phrased as refreshing recollections and follow it appropriately.
Do you now remember there was more to your answer?
Yes,
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn it over, turn the paper over, please.
I can take it on.
Ask the appropriate questions to them.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes,
And could you share the rest of your statement with the jury, please?
the rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Alessi.
Part of the end report. Take a look. You have it.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees. when he was brought to the hospital?
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature.
Yes.
No, it's within the scope. Let's see if she's got the basis.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there's any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Sustained. Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes,
You mentioned that you had information from a police report. How many police reports were you given?
there was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes,
What is it?
this is a police report on this particular case.
Is that a police report from your file?
Yes,
And that police report, is that the police report that you considered?
amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
And in the witness another document?
Let us mark it.
Oh, sorry, let me have that back.
Yeah.
Q for identification.
Thank you. May I approach your own?
Yes.
Second document, is that another document in your file?
Yes,
And is that another report that you considered?
yes,
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Civic R for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I can hand you a document. I'm not going to actually read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you. You submitted the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant,
I'm going to allow it.
that the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of MacLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe that she said, may have I hit him? Did I hit him?
Objection, our main approach, please, briefly.
Okay. Thank you. So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordi-Bello's knowledge and state of mind at the time of her report.
Why is
Thank
it? Okay.
At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
That, yeah, I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes,
Were you aware that the police or Massachusetts State Police by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead,
Yeah, I was given that information.
and the questions of did I hit him? Were you aware of that?
Yes,
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honors.
I'll allow that.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed relative to the broken right taillight, she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you've had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes,
And you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
That is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible,
Could it be consistent with sharp shards from broken plastic?
possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand knowledge of how the laceration on the nose happened?
I do not have firsthand knowledge.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Alessi.
Thank you, Your Honor. Dr. Scordi-Bello, this Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol too, you said, right?
Correct, Your
Go right
Honor.
ahead. Yes.
Dr. May I?
Yes.
Dr. Scordi-Bello, may I stand by the witness here?
Yes.
Thank you. Dr. Scordi-Bello, I am providing you with a document. Up at the top, it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes,
And that medication is,
it's an antacid.
right, and so omeprazole is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying. Yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers. And what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption,
It's possible.
as opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him? Could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scordi-Bello.
All right, doctor, you are all set.
Thank you, Your Honor.
I'm going to see counsel at sidebar.
Up, this number 12. Right? Wait. I think that perhaps if we don't have one more before the end of the day, then Mike is gonna win. This has been quite the back and forth. I'm pretty sure they're going to be talking scheduling right now, and that because it's almost 4 o'clock, it's like, what is it, 20 of. they will be calling it for the day before calling a new witness. We could have a tie today. Yes, if we get one more, we have a tie for the record. Yes, we do. I know the students are getting ready to leave. I saw that, Maggie. They're all taking off their earphones, their headphones, and all, and they're disconnecting. I saw that. It's like they're getting ready to bolt out.
All right, so jurors, that is it for today. I'm
Thought
told
so.
that we are on schedule. So with that, I'm going to let you go a few minutes. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media. So we'll see you tomorrow morning.
Rest of the jury.
Okay. Well, there we go. No more jury. We would just leave it for a minute in case they decide to discuss something, as usual. But looks like we are all done for the day, everybody. It's a nap time for a few of us. At least for me. Cool.
You may be seated.
Okay, looks like we're
All
still in
right, so
session.
Mr. Alessi, I'll hear you. I'll hear you, Mr. Alessi.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes, that
Okay.
my understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to get. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds matter in the analysis of many factors. I won't go into them other than to say, I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that.
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA at
All right,
all.
so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense and theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's
all
question.
right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
On my case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first trial.
All right. I thought Burgess was, no?
No, neither.
Okay.
No one from Aperture was.
Yeah, I knew
Your Honor.
Aperture was, and I thought he may have been something. The name just sounded.
Neither
familiar.
Burgess nor Welcher were
Okay.
part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire passage. Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government suggestion and has stated that it's going to allow the defense to proffer two expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We will go to try to begin to prep at the end of the weekend. there's no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what would we like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders. And so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide background information.
Right. Mr. Alessi, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Alessi. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Court, all rise.
Goodbye.
So she got out all the information, but it seems like, well, we know that the defense was always already rented outside the discovery, giving extra time for their partner witnesses. And now they're upset that there's no information that maybe will allow the Commonwealth to present information that ARCA won't be allowed to address. And so the Commonwealth says, well, okay, in that case, then you guys go get and take extra time to address that, but then we're going to bring an auto witness and do and they don't want to they don't want to allow the Commonwealth to say that they just got. I mean, that's what I'm meaning. I just find it rather ironic that Alessi is getting so indignant about discovery violation. Like, have you been here every hearing all the way through? Like, each show it's at the end of the day. Sorry about that. All right. You can't understand me? Okay. I'm going to put it in.